the record on all of those things that happened after appearances.
The Heights lawyer guardian ad litem.
Ms. Saja Thomas, counsel for the department.
Hannah Trout with the department.
Michael Brooks, I represent Father Zane Ridenour. Mr. Ridenour, identify yourself.
Now we've lost him. After all that.
We wish to proceed with my client, Your Honor.
Yes, let me make sure.
Would you like Mr. Powell to call over the jail, Your Honor?
Yes, please. Thank you. All right, go ahead.
Michael McFarland, representing Brittany Underhill. Brittany, please introduce yourself to the court.
I'm Brittany Underhill. I am the mother of Liz and Rocky.
Thank you.
Thank you. All right, we only caught part of that, but we caught the important part, which was your name. So when it comes time for you to further contribute, we'll need you to probably move a little closer to your microphone. So I just want to let you know. Also, if it's not actively your turn, you may see me come across and mute your screen because that cuts down on the background noise that we get through our speaker system here, which is terrible and interferes with our record. Okay. All right. As it relates to the developments leading up to us assuming the record, who would like to be up?
Your Honor, I can.
Go ahead.
I've discussed my client, number one, who went over her rights again with her, the purpose of the day, and that we're scheduled for a bench trial and adjudication. At this point, she wishes to make admissions. We would stipulate to the testimony given by the worker at the preliminary hearing. I believe fellow counsel will do the same. I understand that there is a case service plan. My client has already been served. We would like that to be adopted today. We would also like the agency to explore the possibility of my client living with relative placement for the minor child right now. And we also discussed that the ICWA search with the Navajo, that they're still, that they indicated that they're researching the ICWA issue. I think that's everything that I have. And we do waive reading the petition.
Very good. Mr. Brooks, would you like to update the record as it relates to your contacts with your client?
I have spoken with him as recently as earlier this afternoon. It is my understanding that he is willing to admit paragraph 27 and 28 with regards his incarceration and potential sentencing on a felony charge he's in jail for. The rest of the matter, not going to respond to it. It's just the investigation of the caseworker into the background of this man. Basically, what I think he's going to tell us is that he has been in the Lenawee County Jail for the last 18 months. A long time. And that he has pleaded guilty to a plea bargain. He has admitted 4 of 11 felony charges, and the others are going to be dismissed. And he has been told he is going to be sentenced to 38 months in prison with credit for 18 months' time served in the Lenawee County Jail, meaning there will be a remaining 20 months yet to serve. That's my understanding.
I believe he has successfully joined us. Mr. Ridenour, could you confirm you can hear us by giving us your name, please?
Yes, sir. Yes, ma'am. Zane Ridenour.
Thank you. All right.
You want me to repeat it?
Nope, I think he's aware.
My client is going to admit paragraphs 27 and 28, which deal with his current incarceration and potential sentencing for charges that he's entered a plea on. He has been serving, he's been in Lenawee County Jail for 18 months. He has pled to a reduced charge wherein 7 of 11 felony charges have been dropped in exchange for a plea to 4. He has been told that he is going to be sentenced to 38 months in prison with credit for the 18 months he has already served in the Lenawee County Jail. Is that an accurate statement, sir?
Yes, yes, sir.
Thank you. Okay. Ms. Heiss, what are your thoughts about the requested plea?
Your Honor, I think it'd be in the children's best interest for the parents to accept the adjudication and get working on services. Mother has already had a successful start. Father is without the ability to do services until he gets to his final destination. And so, yes, I agree with the plea ideas outlined.
Things get ugly fast when the father admits he's sitting in jail after multiple felony charges. The courtroom energy completely shifts once everyone realizes he could remain.
Thank you. I see we have the affidavit of parentage number as it relates to the oldest child. There is, as it appears to the court, a question as to the legal or putative status of Mr. Ridenour as it relates to the younger child. So Ms. Thomas, as you address whether or not you would like the court to follow the direction to allow the parents to enter a plea, I'd like, if you have one, an update on that issue.
I do have an update, Your Honor. To clarify, I believe that the AOP is for the youngest child, and then a DNA test was performed for the older child. And we do have those results back, but literally just got them today, I believe. But it does confirm paternity with Mr. Ridenour. Okay, and the Ms. Burgess, the foster care worker, did email a copy of those results to the court, but again, this was literally just at like 10 this morning, I think. So I'm not sure if it made it to be in the file.
Mr. Ridenour, did you hear what the attorney said? The DNA test on Rocky came back that you're the dad?
Yes, sir.
Alice, yes. Your daughter. Okay, so was there a copy of the affidavit of parentage supplied? I don't see one attached to the initial petition, but I know that sometimes those get separated.
We do have a copy of it, Your Honor. I don't know that I submitted it with the petition, but if this court would like to accept the DNA results and the affidavit of parentage, I do have that.
I do have the DNA results. If I could, Mr. Brooks, Mr. McFarland, do you have copies of the DNA results?
No,
Do you need copies, want copies?
I would like a copy for my file, sure.
I feel the same way. I mean, I believe her, but it'd be nice to put it in file.
Ms. Heiss?
I agree.
Very good. All right. Any objections to me receiving the DNA test and the affidavit of parentage into the court file?
No,
No,
No.
Very good. Thank you, Deputy James. I have the DNA results. I also have the affidavit of parentage in hand. Thank you. All right. So we have then confirmation that Mr. Zane Ridenour is the legal father of both children. As it relates to AR, that is because the DNA test has confirmed that relationship. And as to RR, I have the affidavit of parentage, which does contain the state file number, which will be noted in the court order as a result of today's hearing, which means that he does have the status necessary to take responsibility for both children and enter that plea as it relates to his future legal obligations on that point. All right, Mr. Brooks, do you know if your client would like the allegations in the petition read onto the record, or if he would like to waive that?
I beg pardon, Your Honor.
Do you know if your client would like the allegations read into the record that are in the initial petition, or would he like to waive that?
I'll waive them, Your Honor.
Thank you. All right. Are there any other court cases that would affect these children? Does anyone know?
Well, my client's gonna be sentenced, I'm told, on Friday, but he's been told what the sentence is gonna be.
I meant more like custody, visitation, guardianship.
Oh, no, there's nothing else.
Not that I'm aware of, Your Honor.
Being said that, have your names, would you swear in, please, Miss Brittany Underhill and Zane Ridnour?
Could the two of you please raise your right hand? Mr. Ridnour, can you hear me, sir?
Yeah.
Thank you. Thank you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Yes.
sir.
Thank you.
Okay. All right, I'm gonna go through your rights with both of you and some questions to make sure that you understand what's happening here this afternoon and that you agree. Is it true, Mr. Mr. Zane Ridnour, that you wish to admit to some of the allegations in the complaints, or I'm sorry, the petition today and enter a plea?
Yes, ma'am.
Ms. Brittany Underhill, it's my understanding that you wish to admit to all of the allegations that may apply to you and enter a plea, is that right?
Yes, ma'am.
All right, if I accept your plea, both of you are giving up your right to a trial by judge or a trial by jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence as it relates to each of you individually. The right to have any witnesses appear and testify under oath at trial. The right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. You would, of course, have an attorney to represent you during that process, as you will today and all future hearings. Do both of you understand that you'd be giving up or waiving the rights I've just indicated to you if you admit the allegations in the petition as we have discussed, Mr. Ridnour?
Yes, ma'am.
Ms. Underhill?
Yes.
Now the judge begins reading rights and consequences like a warning shot. Both parents quietly agree to waive trial rights, while the court explains how parental rights could eventually be terminated forever.
With regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there is no need for the court to be involved. If it appears that there's a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the children, in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea, Mr. Ridnour?
Yes, ma'am.
Ms. Underhill?
Yes, ma'am.
Do you have any questions about any of the information I've given you so far, Mr. Ridnour?
No, ma'am.
Ms. Underhill?
No, ma'am.
All right, is anyone making you admit to the allegations in the petition, Mr. Ridnour?
No, ma'am.
Ms. Underhill?
No, ma'am.
Has anyone threatened you in order to get you to admit to the allegations in the petition today, Mr. Ridnour?
No, ma'am.
Ms. Underhill?
No, ma'am.
All right, has anyone promised you anything in order to get you to enter a plea, Mr. Ridnour?
No, ma'am.
Ms. Underhill?
No, ma'am.
Are you under the influence of drugs, alcohol, or anything else that could get in the way of you understanding what you're doing this afternoon, Mr. Ridnour?
Yes, ma'am.
What would be in the way of you understanding what you're doing this afternoon?
Oh, no, no, ma'am. My bad.
Oh, that's all right. I just want to make, it's definitely important that you understand the question.
Yes, ma'am.
Okay, so Ms. Underhill, are you under the influence of anything that could get in the way of you understanding what you're doing this afternoon, like drugs or alcohol?
No, ma'am.
All right. Would you say your decision to enter a plea is one you've made of your own free will, Mr. Ridnour?
Yes, ma'am.
Ms. Underhill?
Yes, ma'am.
Very good. As it relates to the factual basis of the plea, Mr. Ridnour, I'm supposed to look at 27 and 28, which is, you're incarcerated, you were aware of Ms. Underhill's substance abuse, and that you didn't make proper custody arrangements to adequately safeguard the children. Is that right?
Yes, ma'am.
You are unable to care for the children because of your incarceration?
Yes, ma'am.
All right, what is it that you're incarcerated for?
I'm taking a plea tomorrow for receiving, stealing stolen property, felony firearm, possession of methamphetamine, and fleeing and looting.
Okay, I got the first one, but I couldn't quite understand the second two. Could you slow down a little for me and repeat those?
Fleeing and looting,
Fleeing and eluding?
yes, ma'am, and possession of methamphetamine.
Possession of methamphetamine, I believe.
Oh, is that right? Possession of methamphetamine?
Yes, ma'am.
All right, should I infer from that you may have an issue with methamphetamines or any kind of drug or alcohol issues that would need to be addressed?
No,
All right. And you think you're going to be incarcerated for at least 20 months, is that right?
yes, ma'am.
Are there any other issues that we're going to need to look at that you would need services for, like referrals for a job or housing or education or psychology once you're released?
No, I'm pretty sure MDOC takes care of all that.
All right. Well, if I were to try and return your child to your care, what would the challenges be that you would like to remedy so that you could be the best parent that you could be? Would it be parenting education, counseling? What do you see as your needs?
Counseling, like a parenting class, so you can do what's best for the kids.
All right. Thank you. Further questions for your client on the factual basis?
Just for your information, sir, I've just received a copy of the DNA report dated February 5th. And it says you are 99.9999% positive for being the father of this child, okay?
Yes, sir.
No, I have nothing else.
Anyone else have questions for this witness on the factual basis?
No, thank you.
Yeah.
All
No,
right. Okay, Ms. Underhill, let's go to you. I'm supposed to review the petition in its entirety. I'm aware that there was an outstanding question at the time that this petition was filed as to whether or not you were continuing to struggle with substances. So is that something, but that there's a history of that? Is that something that you're going to be needing to?
All right, guys. The father tries to soften the damage by claiming parenting classes could help him become a better parent after release. But immediately afterward,
Tackle in order to create a safe environment for your children, in your opinion?
No, the substance that I use is legal. It's marijuana, which I very much do responsibly, but I am more than willing to participate in any program that you guys would like me to attend. I mean, I'm not opposed to it.
All right. So would you be willing to take a substance abuse evaluation, for example, and be open and honest about your history of use as well as your current use and needs?
Yes, ma'am.
All right. It looks like there may be some need to assist you with parent education based on some of the allegations I'm reading here today about the state of your housing and some other allegations in some of these other paragraphs without getting too far into those. Would you agree?
Yeah, I'm sorry, were you?
Do you think you need some parenting education?
Oh, honestly, I'm more than willing to do those. I've already enrolled in Michigan Resources and I have started doing some of that on my own. As a parent, I feel there's always room to grow, so I'm not opposed to that at all.
Very good. Are you currently employed?
I work when there is work to be done, mudding and drywalling. But I currently am enrolled in New Hampshire University online, and I will be attending school full time online starting February 24th.
Do you have a place to live at this time?
Currently, I stay wherever I'm able to stay until I'm able to find housing. I know if the court grants it and is okay with it, my brother and sister-in-law are both more than willing to let me stay with them while I work on getting my own housing, which the children are residing there, and it is a very positive environment, which would
Okay.
give me somewhere stable to be while I do everything that's needing to be done.
All right. And you've read over the petition, you're familiar with the facts in there?
Yes, ma'am.
Okay, and that's what you want me to consider as far as the basis for your plea?
Yes, ma'am.
All right. Questions on the factual basis of her plea?
No, thank you.
Your Honor, as Mr. McFarland had stated on the earlier, for the sidebar, if the other attorneys are agreeable, we would ask the court to take judicial notice of the testimony that was provided at the preliminary hearing stage.
No objection.
I have no objection.
I have no objection.
Very well, I'll take that under advisement as well as the contents of the petition. All right, counselors, are we satisfied with the factual basis of the plea and the advice of rights?
I am.
Yes.
Yes, Your
Yes.
Honor.
Thank you. The court is also satisfied, as well as satisfied that the plea by both parents was understandably, knowingly, and voluntarily made, the full understanding of the consequences, and that the record supports that one or more of the statutory grounds alleged in the petition are true. As it relates to the father, he was not providing proper care and custody as he was incarcerated due to some criminality challenges that he'll need to continue to tackle. As an extension of that as well, that criminality would be something that would characterize the home or environment of the child if the child were to be in his care. And of course, the neglect on the medical, educational, and daily support of the children is also implicated. As it relates to the mother, the same applies with the exception of the criminality aspect of it. In her case, it's more about some of the neglect that was happening that's outlined in the petition itself, as well as was visited during the testimony during the prelim. All right. Do the attorneys wish for me to get any more specific into the details of that, or are you satisfied with me taking judicial notice of the facts and circumstances in the petition as well as the preliminary hearing testimony?
I'm satisfied.
I'm satisfied.
I'm satisfied as well.
The discussion then shifts towards strict service plans involving counseling, parenting education, housing, employment, and evaluations. The mother surprisingly agrees to start immediately.
I am satisfied as well, Your Honor.
All right, thank you, ladies and gentlemen. Ms. Underhill, and Mr. Ridnour, the next stage of things is our disposition. So that is where I would look at what's called a case services plan and potentially order you into it. That identifies the issues that we'd be looking for, the court looks for, and the attorneys litigate as far as whether or not you have overcome some of these challenges that have just been outlined on the record today. Typically, case services plans are going to ask you to, for example, Mr. Ridnour, if there's programming available to you, to engage in that programming, to correspond with the foster care caseworker, to look at things like parent education, psychological services, those kinds of things, and that would be in the case services plan. Once you're released, we'd be looking for you to establish housing, safe housing, employment so that you could support your children, things like that. Ms. Underhill, I understand that there may potentially already be a case services plan that you are satisfied with. Is that true?
Yes.
All right, so typically you'd have 28 days between today and the dispositional hearing to review that before it becomes part of the court's order. You have the right to that, but you can waive that if you want me to enter you into the case services plan today. And I do have a proposed case services plan that was submitted in anticipation of today's hearing. It does appear to have your signature on it. Do you want me to order you into this today?
Yes, and then that would allow us to get started on everything sooner, correct?
That's true.
Okay.
You're always-
Yes.
You're always welcome to do these things voluntarily, but I think the department has an easier time making referrals and securing funding for services once it becomes a court order. So I don't want you to be confused. You can do these things voluntarily if you want your 28 days.
Well, I've already started some of these things before today. So I mean, I'm already in the process of completing some of what's on here anyway. So I mean, I'm okay with that.
All right,
You're-
Mr.
Your Honor, the only suggestion we would ask is that the agency explore my client's ability to live with the current placement.
Well, I can tell you my perspective would be that unless that's a long-term plan, which your client has indicated that it isn't, that we would still be looking for her to establish her own independent housing.
Right, I'm just saying, in the interim, Your Honor, we'd like that explored.
All right. I think that was discussed in our sidebar and was amenable.
Yeah, yes, Your Honor, there are several considerations when we have relative placement and parents living with relative placement, such as funding and appropriateness and buy-in and input from the relative caregiver. And I think that is most appropriately discussed during a family team meeting.
Agreed.
Very good. Right. I don't have a proposed case services plan for your client, Mr. Ridenour, Mr. Brooks, so I would assume that we need to set a time for his disposition.
Your Honor, if I may, actually it's a little different, but there is the case service plan is combined with both parents. And at the time that it was provided to the court, Mr. Ridenour had not signed it, but since then, he has signed a copy. It has been reviewed with Ms. Burgess, and I do have a copy of that with his signature if you'd like that.
Would you like to have a look at that, Mr. Brooks?
Please. Just one paragraph?
Just the same page, but it would be a document that's in a case service.
Well, apparently my client's already signed it, Your Honor, so I'll take a look at the rest of it. If there's any issues, I'll contact counsel.
Very good. All right, Mr. Ridenour, is it true that you would also like to waive your right to the 28 days and enter into a case services plan today?
Yes, ma'am.
All right. There is a plan with your signature on it. Is that the one you want to use?
Yes, ma'am.
All right, very good. All right, if there are any changes or anything comes up, then what you do is you talk with your foster care case services, foster care person. Okay, so if there's services specifically that you engage in or things that you want, reach out and ask them to put that into your case services plan if you want to. And then make sure you give me the information so I can see what you're doing between now and when we come back for our next review. Any questions?
No, ma'am. Thank you.
All right. All right. Ms. Heiss, have you looked at the case services plans for the parents?
Your Honor, I have looked at those and I believe they adequately address the concerns, and that because they're modifiable, I know going forward, we'll look at them every 90 days, but they should give us a good start on, and I believe the mother has started on several of these pieces. I visited the children in person, and mother had missed the visit that I was at, but since then, changes have been made so that mom is improving her visits. The children's needs are all being met in a relative placement, and I intend to be part of the family team meeting to discuss mother maybe living there so that her 2 plus the 5 that already live there, those children can all have all their needs met in the best way possible. And I understand that funding may be a part of that, but
The discussion then shifts towards strict service plans involving counseling, parenting education, housing, employment, and evaluations. The mother surprisingly agrees to start immediately.
it would be interesting because then maybe Mrs. Edwards could serve in a parent professional partner kind of role as opposed to she's doing the transportation for visits and supervising visits and transporting after. So I'll be part of that planning, but the children's needs are being met in the current placement. Thank you.
I have some questions on a couple things on it, specifically around parenting time, but I know also I have a proposed court report and some ICWA documents that you'd like to review, Ms. Thomas, a witness.
Yes, if Ms. Burgess can be sworn in, please.
Come on up to our witness stand, Ms. Burgess.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Give us your full name for the record, please.
Brenda Burgess.
Thank you. Go ahead.
Thank you. Ms. Burgess, how are you involved in this matter?
I was assigned as foster care caseworker.
And as a foster care caseworker, did you have the opportunity to draft the court report and the proposed case service plans that are included for today's hearing?
Yes, I did.
And are there any updates or modifications that need to be made to this document or any documents that have been circulated since you've submitted this?
I don't believe so.
And other than this packet of documents, I guess, the case service plan and the court report, the only other document that was circulated was the DNA. Is that correct?
Correct.
And that's already been received by the court. What is the current permanency goal for the children?
It's reunification.
And as it stands today, have either of the parents rectified any of the barriers that have caused the children to come into care?
No.
And what are the, can you just please briefly explain the services offered by the agency on this voluntary basis, sort of in this interim period of time, and whether there's been any cooperation on those?
Okay. There was a family team meeting, and we're doing a visitation coach for parenting time. There was DNA testing, and that was received back. We've done trauma screening checklists, a Head Start for Alice, and an early on referral for Rocky. We've provided some things for the placement, beds, dressers, car seat, Christmas gifts. And I also made a foster care supported visitation referral for mom, and there's about a 4-week waiting list on that.
And some of these services that you provided seem like they would have to include some sort of either a release or like a permission from mom.
Yes.
And has she been agreeable to signing all of those to get services started?
Yes, she has.
Great. And do you believe that based on the current condition or the current circumstances for both parents, the children would be at a substantial risk of harm if returned to their care and custody today?
I do.
And what is the risk of harm that would be posed to the children?
Dad is incarcerated and unable to take placement. Mom does not have any housing, and so she's working on that. And she's agreeable to other services.
One of the, I know that sometimes there's some lap or crossover between who provides what to the court, but part of what the court has received are ICWA documentations for documents from the ICWA search. Are you familiar with any of that?
Yes.
Okay. Your Honor, may I ask what the court has in its file regarding ICWA?
I have. We appear at the outset. I had a mail receipt and a green card to VIA, and I was looking for the inquiry back in December. They, I have a giant stack of things, which is great. Appears to be the inquiries received February 5th on Alice, or on AR, I should say. With a copy of the documents that were pending, as well as I think a set of the same documents that were sent with regard to the other child. Let me just verify that. These were done, it looks like, by Ms. Hannah Trout. Yes, there's also the green, another, it looks like another copy of the green card receipt indicating the Navajo Regional Social Services Office received a copy, some certified mail receipts indicating that
The foster worker then explains the aggressive reunification efforts already underway, including visits, bedtime calls, transportation assistance, parenting support,
the post office is verifying the service to the Navajo Nation in Arizona, the Navajo Regional Social Services Office, and the VIA Midwest Regional Office. The green card receipt indicating the Navajo Nation in Arizona received their inquiry. And a letter regarding both children to Ms. Trout from the Navajo Indian Child Welfare Act Program Division of Social Services in Arizona. Is that a complete set of all the documents that we have currently, Ms. Burgess, do you know?
I believe so. I know Ms. Trout provided those to the court. And that sounds accurate.
Yes, she nodded at me from her direction as well.
Yes, and I just want to confirm, that is what I have in my file. And from my understanding, that is what the department has received so far.
All right, counselors, do you have all of those documents as well? You know,
Well, I have a packet, Your Honor. I haven't filed you continuously, but I presume it's very safe that I received.
Mr. Brooks?
Yes, I agree with Mr. McFarland.
All
What's that
right,
again?
I think McFarland is wrong.
all right. Jokes aside, it looks like these were sent to January 25th and received February 2nd. January 29th is the letter date. So we are almost at the outset of the 2 weeks left for any other tribe to intervene. Nevertheless, it would appear that we would still be looking for active efforts until we have that 2-week time frame that's, or window that's closed, or any of the tribes respond and decide to intervene. Would you concur, Ms. Thomas?
I would, Your Honor, and I would also just like to note that I appreciate the Navajo Nation sending the letter and reminding us of that standard. It's always helpful when they at least communicate with us. So I was actually going to ask Ms. Burgess a question on that point, if I may.
Go right ahead.
Thank you. Ms. Burgess, given the active effort standard, can you testify to what the ongoing vigorous and concentrated level of casework that you would put forth to ensure that this family, I guess, can maintain its level of connection and preservation towards civil reunification?
Okay, so I've gone over the case service plan with both parents and talking about each item. I've made a home, I'm not sure if I'm correct on this, but I made a home visit where mom was staying at the time. I've met with dad a couple of times on Zoom. We're doing parenting time 2 to 3 times per week at DHHS. We've arranged phone calls for mom to call the placement every evening at 8 o'clock, which is bedtime, and I have contacted paternal grandmother, and we're in the process of, she lives in Ohio, so we're in the process of getting her background checks so that she can have that contact with the kids and also able to provide the phone or the contact with dad, because she speaks to dad every day, and can facilitate that contact.
And your court report also indicates that, or I'm sorry, maybe it was Ms. Heiss is her report, but there's also transportation assistance regarding parenting time. Is that for the children to come to parenting time and be present, or for mom?
But really it's for both. And I did offer mom tokens for Illinois trans, but then she obtained a car. And so she said that she didn't need those things.
And if there's any issue with like getting to parenting time, from my understanding, that might be something the department can assist, like gas cards, if there's a receipt or mileage calculated, things like that.
Yes.
Okay. And as it relates to like doctor's appointments and informing her of, and both the parents, I guess, of doctor's appointments, advance notice of that and an opportunity to discuss any barriers to attending.
Yes.
Okay. And as it relates to the case service plan, you have both the parent signatures, and you've met with them regarding that. Do you believe that the case service plan adequately addresses the concerns that were brought forth in the petition?
I do.
Thank you. Is there anything else you'd like to report for the court today, whether it's the children or anything else?
No.
Thank you. I have no further questions, Your Honor. I would move to admit the court report, the case service plan. Also, I know that you've already received the DNA and then also the ICWA documentation that was provided.
No objection.
No objection.
No objection.
Thank you. They are all received. Questions for this witness, Mr. McFarland?
No.
Mr. Brooks?
I have none.
Ms. Heiss?
No questions, thank you.
All right, did you say that the father is getting visitation through his mom?
The judge pushes even harder by questioning how the incarcerated father can maintain contact with the children while behind bars. At the same time, concerns explode over missed visits by the mother.
Not with the kids at this time. He did have one phone call, video call on Christmas with the kids.
All right, have you checked in with where he's incarcerated to see if he would be able to visit with them?
I talked to him about it, and he does get one call a week. And then I was saying that his mom, he and his mom have contact every day. So,
If he's got contact with his mom every day, but he only gets one phone call a week, help me understand.
apparently she provides payment for the other calls.
Would the department be able to provide any kind of funding to facilitate contact between him and his children?
I don't know. I don't think we've ever done that.
Would you be willing to
I
look
can
at that?
into it.
Very good. And as well as any materials that he could use for parenting education, monthly updates, all of the other things that we sometimes look for in the incarcerated parent protocol moving forward as well.
Yes.
All right, great.
Your Honor, I'm sorry to interrupt. Ms. Underhill was kicked out of Zoom somehow. Oh, I guess she's in the waiting room.
Oh,
I just admitted her back in if she's able to successfully join. All right, any questions based on my questions?
No.
No, Your Honor.
no.
No.
Thank you for your testimony. We return to your seat. Any other witnesses?
No, Your Honor.
Just to secure my client's email address before we close or afterwards, Your Honor, since she's homeless.
Well, we'll do that after we're finished with our broadcast.
I have no witnesses. There's no one I wish to call.
Thank you.
No witnesses, thank you.
Comments?
No, Your Honor.
None.
Your Honor, if we when we explore mother living with the relative placement, another piece that I gained from the court report is that placement has 5 children plus these 2 going in different directions. Miss Edwards had been picking up the children, bringing them to visit. When mom didn't show, Miss Edwards would take the children home and did not get paid for that service. So I think it might be, even if mother can't live at the house, I don't know why we can't also explore her visiting there or doing some of the but having supervised visits there or something, but I think there's an opportunity for mother to support the placement, and I'll be looking into that. Thank you.
Yes, I appreciate that. I would also be willing to sign a court order if necessary that indicates that mom should confirm her parenting time so that the children don't go into the car anticipating a visit at the time, effort, and expense of the department or one of our service providers, and then she's not able to make that visit. So I'll ask you to determine during your FDM what kind of time frame that would look like, if it's an hour, 2 hours, or 24 hours. She'll need to confirm her parenting time so that we can avoid that. That's not good for the kids or our service providers. As far as their bond goes with the parent, and the services we have are limited, as we know. So we'll ask mom to confirm her visits ahead of time to avoid that particular instance. And I would ask formally also for that FTM on visitation, as well as living arrangements for mom that would allow her to see the children and maintain her bond as she is legally able to do. We've already addressed with Ms. Burgess visitation efforts for dad and what I'll be looking for in the upcoming months for updates on that, as well as services while he's incarcerated. I do find all parties were given notice for today's hearings. It was supposed to be our bench trial. Both parents consented to the adjudication as well as waived their right to the 28 days ahead of disposition. And I've asked the court to enter the case services plan, which I think does accurately reflect the challenges ahead of them in order to relieve the risk of harm so that the child or children could potentially be released to them, with the exception of the indication of parenting time for Mr. Ridenour being suspended for court order due to incarceration. So I will indicate parenting time for Mr. Ridenour should be weekly or as available. So with that change, everything else is received, accepted, and will become the part of the court's order as a result of today's hearing. I do find active efforts are being made by the department, and that does include those extra efforts to secure parenting time for mom, for example, that we did discuss with our Ms. Edwards making the extra effort to pick up the children and transport them for visitation, for example. Continued efforts, active efforts would look like making referrals, but also assisting in phone calls to set up appointments as necessary for Ms. Underhill. Those extra efforts to try to organize parenting time for Mr. Ridenour, potentially looking at, of course, unique tribal opportunities and information to pass along to the children as well as each parent, as that may be applicable. But for today, I do find the department's meeting its obligations and that there is a significant risk of harm associated with returning either child to either parent at this time. Obviously, Mr. Ridenour has some challenges he's facing on the criminal landscape and remains unavailable due to incarceration. I am aware from our sidebar that he is asking for his relatives, his mother, for example, and maybe another relative to visit with the child. And so I think Ms. Burgess is already actively looking at that in addition to the request for placement that he's made on that point. And I trust that will continue moving forward. And then, of course, Ms. Underhill has the challenges that were outlined today that we talked about with housing and stable employment services, evaluation on parenting skills education, so that she would be able to mark some progress as she embarks on those challenges. But for now, the children are in the safest and the least restrictive environment. It is with a relative that will offer additional visits and benefits to Ms. Underhill should she choose to utilize those, and hopefully also to Mr. Ridenour. Our next hearing will be a review. So we'll be looking at what progress the parents have made in the next 3 months at our next review, which will be scheduled in May. I have Tuesday, April 30th available at 9 a.m. if that works for everyone. Actually, you know what? We could do it a little bit sooner if you want April 23rd at 9.
Time?
At 9 AM. Or I've got the morning open if you prefer 10 or 11.
Works for me.
All right, our first regular review then will be April 23rd, 2024 at 9 AM. We'll of course look for any updates on Mr. Ridenour's location, wherever he may be, from his purchase in anticipation of that. You both should receive a copy of the court report ahead of time. We'll make some time for you to talk with your attorneys briefly if you need to. But unless there's any questions.
All right, guys. The hearing closes with the judge officially ruling that returning the children to either parent would create a serious risk of harm. The father faces incarceration battles, while the mother still struggles with housing and stability. A future review hearing is scheduled, but the message from this courtroom could not be clearer. Real progress must happen immediately, or the consequences will become devastating.